if you hear ISO or CENELEC or JTC whatever. Oh, you're not short, good. And who's more the newbie here? Wanted to get some simple start? A few, okay. So please panelists, take into, please consider your different audience. I will be quick now in introducing what we have here. The topic is technical standards and on ethics and or regulation. And we have a few presentations of the distinguished panelists we have here. From the right, I will introduce everybody now and then hand over to the moderator, and then we will go for each individual statement. Sarah Spiekermann, from your side, left side. Since 2009, she's chair of the Institute for Information Systems and Society at Vienna University of Economics and Business. We've met long before, when you were a student, I think, yes, and active in various topics, among others, ubiquitous computing, as it was called, but also in transparency issues and everything related with data protection and privacy. Right now, she has also done a lot of work on digital ethics. She is there a scientist, of course, an author, speaker, and advisor, and has published several books on digital ethics and also networks of control. And in 2016, she funded the Privacy and Sustainable Computing Lab at Vienna University, which is a thing really noteworthy with multidisciplinary research, and I'm sure we will hear and see a lot of the results, not only today, but also in the next years. To the left then, right from your side, is Alessandro Guarino. He represents Italy in CENELEC. CEN is the Comité Européen de Normalisation, that is the standardization committee of Europe, and CENELEC, the same for electrotechnical stuff. He's a senior information security professional, also a researcher, but not only from the academics, but a founder and CEO of a company, a consultancy firm that is providing services for cybersecurity, privacy, and data protection. He's also involved with ISO, contributed to different standards, among others cybersecurity and digital investigation, which is not necessarily the same as data protection and privacy. And now chairs, among others, the JTC 8, that is privacy management in products and services. Then one step further, that's Mr. Robot Ethics, Alan Winfield from UK. We debated how difficult it will be next year to go from the UK to Brussels. Last day it was possible. He's professor of robot ethics at the University of the West of England in Bristol, but also visiting professor at the University of York. He co-founded the Bristol Robotics Lab in 2004 and is now mainly interested in the field of cognitive robotics. If we want to summarize, I think it's good to look at the Twitter account, engineer, robo-ethicist, and pro-feminist. Interested in robots as working models of life, evolution, intelligence, and culture. For the standardization, he's involved in IEEE standards on transparency of autonomous systems and also intelligent systems. And this will be the background for today. One step further is Kai Rannen. He's the chair of mobile business and multilateral security at Goethe University in Frankfurt, and also visiting a professor in the National Institute for Informatics in Tokyo. We've also known each other for decades now in the field of multilateral security, which also encompasses many things of data protection and privacy. But for me, he is also the one researcher in this field in Germany, representing Germany, the idea of data protection and privacy in standardization from the background of academics. I know that your talk will also dig into what is happening on this level, therefore I cut you short now. But perhaps to know, one of the main fields is identity management and privacy technologies, and there has been many development since 12 years, I think, and there will be probably more development. And then I would like to introduce the moderator. This is Paul Nemitz. He is from the European Commission, and now you are the principal advisor in DG Justice and Consumers. You're reporting directly to the Director General, and therefore you're very powerful and mighty, and that's also helpful for the panel, but also in collaboration, because we both are serving as members of the Data Ethics Commission of Germany. We will see our joint results. There are 14 more people involved, so it's not only our failure or success if you read the recommendations in September, but I'm pretty sure that we are both very much struggling to have good results and also want to have input from this panel. So, Paul, I hand over to you to give a very short introduction on the topic and then taking care of all our panelists.
Yes, thank you very much. What is the interplay between regulation and technical standards in the field of digital privacy and ethics? This is our subject. Substitution or complementarity, these are terms we will be looking at. Laws in terms of regulations. Well, I make immediately the a little bit small lawyer's comment, but still important. The word regulation mystifies or doesn't show clearly whether we talk about a parliamentary law, therefore with democratic legitimacy, or a regulation in terms of rules being set by the executive. So we talk here about also the importance of democratic process in these times of populism and democracy being in a squeeze between technology and populism. Laws, regulations, standards and ethics, these are the subjects our discussion will turn around. And I would like to invite Sarah Spiekermann to start with her statement. Each speaker has
5 minutes.
5 minutes.
If not exceptions have been.
Yes, and Marit has her whip with her. So Sarah, off you go.
Thank you very much for your attention. You hear me? Wonderful. So it's my pleasure to set a little bit the scenes of the panel. First of all, as you all know, these days we talk a lot not only about privacy but about ethics, and especially ethics in artificial intelligence and all those smart systems coming up. But very rarely the question is asked, what is actually ethics? And as an ethicist, I would say this is the first question to ask. And we have a long tradition in Europe and in all countries what that is. So, for instance, at the core, the question is, how do you act in a good way? How are you to become a good person? And when we talk about technology, how can technology support us to be good people? So you see already, this is a little bit going beyond the data flows and privacy questions we have right now. And the thing is, when you think about what is good and what is right, and what you should be doing and what you should not be doing, then privacy and all the matters we have been dealing with in this conference have been borderline discussions. Because we have been challenging the digital economy's business models, and we have been questioning in the GDPR how can we ensure that our personal data is not being misused or used against us in such a way that we are actually talking about criminal behavior, where we talk about, criminal is a hard word, but where we talk about behavior that goes beyond what is acceptable to us as people, because we are surveyed, or because we are sanctioned, or because we are manipulated, and all of that. And the law, as you see on the slide here in the black line, is basically where borderline behavior in business models, for instance, goes beyond a point where this is not acceptable for society anymore. I wanted to set the scene a little bit so we all are on the same page of what we're talking about. And now, currently, what we should be working for, I think this is my vision for shaping technology, is that we should try to develop artificial intelligence and robots and these powerful machines in such a way that, that they are not only within the bounds of the law, but that they actually help our societies in a positive way, so that they provide us knowledge that we are more knowledgeable. that they give us freedoms that perhaps we don't have right now, like mobility, that they give us insights into something that we don't know yet. And to build this vision, I'm co-chairing in a major standardization work that is financed and driven by IEEE, and it's called the IEEE P7000 standard, a model process for ethical engineering. And IEEE is also financing today's podium. However, and this is the problem, naturally, any technical system can easily transgress good ethical behavior already by just going beyond a region. For instance, if you look into Alexa or the speech system, voice assistants, the gender roles inherent in communication between people and these kind of robots or agents have a completely different shape in Europe versus in Russia or in the Middle East. Very easily a chatbot can talk about things that are ethically not acceptable in Europe, but very common and normal in other countries. So as technology passes the borders, also when US data processing technologies come to Europe, we perceive this as a privacy intrusion, but perhaps other regions in the US won't care that much. So already by technology going beyond national borders, we have unwillingly, very often, problems of transgression of ethical borders, and we are reaching easily with technology into this borderline conflict. Technology can be built and trained so that we ensure that it is constantly improved. For instance, voice assistants can be trained to learn that there are certain gender models in Europe other than in the US. Or we have had the GDPR, which now forces European operators to build technology in such a way that it corresponds to the value structure that we have in Europe. And this is what we can achieve also in conjunction, in collaboration between technologists and the law. There is one challenge though. Technology creates standards in two ways. Technology can create de facto standards in the market. So for instance, all the discussions we have right now on an ethical ground about Uber and about Facebook and about Google is a field here where so-called technical de facto standards come into our European markets, and we cannot accept them from an ethical perspective, but they're there. And then there is a second aspect, and this is why we have all the representatives here of the major standardization bodies. And this is that the formal standardization bodies that determine how technology is supposed to work can be misused and can be influenced. It happens very early, and it happened to me, that I confronted the situation where a technical standardization body was run by the same lobbyists that influenced the informal working groups at the Commission. It's unacceptable that lobbyism drives technical standardization processes. And this is something that I want to bring to the table today as a matter of discussion. And I want to ask, basically, I want to question a little bit this path from an influenced and biased borderline political process into standardization bodies, where borderline behavior is actually created as de factos and normal formal standards. And I have had this crazy idea, and I know the standardization bodies don't like it so much, that I believe that once we have developed a formal standard on ethical issues, and this is just ethical issues in technology, like for instance robot ethics, that there is something like a committee that is looking at these standards before they are passed into, I don't want to say the law, sometimes it's an extension of the law, before they are set out in the market as the standard. And I have benefited once in my life, I have benefited from such a board, and this is my last sentence, when I negotiated the privacy impact assessment standard for RFID technology. The rule was that when that standard is done, the Article 29 working group, as today the European Board of Privacy Directors, is actually had to look into the standard and agree that this is in the line on the spirit of data protection.
Thank you very much, Sarah.
Thank you.
This was now 8 minutes, but still worth it. This was very good. Good start. And Alan Winfield takes over. We oscillate from the social scientist to the engineer.
Thank you so much, Sarah. So I'm a professor of robot ethics, and people often ask me, what on earth does a professor of robot ethics do? Well, the short answer is that I'm a kind of worrier. I've become a professional worrier. Now, of course, worrying about stuff isn't enough. You know, you need to actually take practical steps. And really, through the last 10 years or so of my journey through ethics, I've got into standards and become a kind of standards geek, I would say now. I've become an evangelist for standards. And in particular, if you like, a subset of standards that we call ethical standards. So until relatively recently, ethical standards really didn't exist. They were only technical or process standards. Now, in recent meetings, and one just in fact early this week, a WEF meeting on AI in government and the public sector, people were saying, yes, but we don't have any standards yet. And of course, I very quickly put my hand up and said, actually, we have one already. It's the one you can see here. It's BS 8611. And I just want to tell you very briefly a little bit about BS 8611. Could you, I've got the clicker, yes, thank you. So it's the world's first ethical standard. In fact, it happens to be in robotics and robotic systems, but it actually applies to AI as well. So what is it? What is BS 8611? Well, in fact, it's a kind of method or toolkit for conducting an ethical risk assessment. Now, I think this is a really powerful idea. And of course, you know, as an old-fashioned safety engineer, I and many of you are used to the idea of risk assessment. It's a normal part of life, if you like. But the key thing is to put the word ethical in front, ethical risk assessment. And of course, ethical risk assessment, if you like, is a bigger, is an enlarged scope to regular risk assessment. So, you know, what I'm doing, in a sense, in advocating for 8611, the use of 8611, and of course the new IEEE P7000 standards that are coming, is that ethical risk assessment should become part of every process. Every organization engaged in robotics and AI development, every government department that procures robotics and AI should conduct ethical risk assessment. It should become a kind of standard thing that we all do. Of course, there's nothing new about ethical risk assessment. It's what research ethics committees have been doing for many, many years. All we're doing here is extending the idea beyond, as it were, the rather narrow scope of research ethics committees to the very much broader scope of robotics and AI development, application, and use. So at that point, I'll stop. Thank you very much indeed.
Thank you, Alan. Okay, I think it would be interesting in the debate maybe to see a few of the elements of the standard. And we come back to this. You have a credit of 3 minutes because you only took 2 minutes 47 seconds. So now Kai Ranneberg, professor from the University of Frankfurt. Please, Kai.
So let me start with thanking IEEE for making this panel actually possible and inviting us all to this very nice opportunity. I got the task, well, basically to discuss and think about can technical standards on ethics actually maybe even replace regulation, or how can they support it? And to try to answer the question, I went through an exercise, and the exercise was look into my own standardization experiences. And most of them have actually happened within an SC27 in ISO IEC JTC1. We'll see more details about that. And then in working group 5, which is working identity management and privacy technologies. So we will step in there, have a quick overlook on the projects, and try to put the projects into context to regulation. In this specific example, the GDPR, because there is actually some context there. See how they have been produced. And then maybe I can give an answer from experience how this interplay between regulation and standardization is actually working, not working, whatever. And as you're dealing with a German professor, there's a summary and an outlook at the end. So this is the world of ISO IEC standardization with somewhere in the middle JTC1. And JTC1 was founded because ISO and IEC couldn't really agree on who's going to do the computerized IT standardization. So they founded a new committee. That's the way how you get consensus. You find a new committee if you cannot agree otherwise. SC27 is somewhere between about 30, 40 other committees, some of them not existing anymore. The most recent one, SC42, artificial intelligence. Founding of SC27 is interesting because it was put up after SC20 was disbanded. SC20 was on cryptology and cryptographic mechanisms. And there was a, let's say, political group in the late 80s who thought standardizing cryptography on a global basis is immoral and is bad. And so then that was disbanded, and SC27 came, and the rest of the story we will see later. But it's an interesting experience when people say, hey, certain things should not be standardized for whatever moral reasons. This tells you SC27 in an overview. Blue is the countries that are really active, orange are the ones that are looking at it. And you will notice these, some of these we can clearly claim to be democracies. Some of them we probably would pretty easily agree are not democracies. Quite a few of them are somewhere in the middle. That is something that needs to be considered. Many of them have actually quite different ethical understandings and moral understandings about family life, personal life, and all of those. And that needs to be somehow covered or not covered. And SC27 has 5 working groups. And among them, there's working group 5. But my personal story with standardization actually started with working group 3. And that is the one on IT security evaluation. And there were criteria, common criteria for security that didn't cover privacy. And I was doing academic papers, and I was fighting with government people who were writing these things in conferences. And then somebody told me, if you really want to have an impact, you have to go to standardization, because as I want to make this a global standard, there they bring their documents in. If you come up with critical questions, they will have to answer you, because they have to give any kind of disposition of comment to a comment that you make. Will be a tough job, but there you really can have influence. So either you want to be serious or not, decide. And I decided I tried to be serious. Took 9 years after that, the common criteria had privacy stuff in it. Not as perfect as you would like it, but remarkably more than there was before. So that is my first personal story with regard to working group 3. And then eventually privacy standardization became more important. It turned out to be useful to do it together with security people, because by then the cryptographers had fought back and said, yes, we can do cryptography and we want to do it. And indeed, they overcame the, let's say, moral or whatever kind of power struggle against them. And we will come later back why it is maybe useful to have security and privacy, but I don't want to overrun. This is a picture of what has happened in working group 5 now in terms of projects. No, you don't need to learn about all of that. What you may want to take a look at is a list on the left. You see application areas, which is sometimes out of working group 5's area, but you see general framework, management, and implementation, specific technical stuff, and then some support documents. That structures a bit how privacy standards are structured. Again, I don't have time to go through all of them. Similar structure for privacy-friendly identity management, because indeed one of the things Marit mentioned it was to document that identity management is a core function for privacy and is extremely sensitive to privacy. So it's good that it's also in there, which was a fight in itself. Actually, there was an NSA candidate for the convenership of this group who had totally different understandings about that. But again, that is, let's say, experience number 2. The fight was close, 3 votes difference, but in the end, the NSA candidate didn't get it. So, regulation. How much time have I left?
3 minutes.
3 minutes, perfect, good. So this is in GDPR, some articles where you can say maybe they have a relation to standardization. And you see the red ones where I think we're quite confident that something could be there. The blue ones you cannot really notice from the black ones, that's okay. So what you can see is, and indeed Working Group 5 has worked towards it, try to fill those gaps and areas that regulation leaves with documents that people can agree on. And in this case, indeed, there was quite a bit of push in this global committee to do something which fits to GDPR, because many people thought GDPR will have a global impact, and we want to have a hand in how this works. And indeed, you meet all kinds of people, nicer ones and maybe not so nice ones, depending from your personal point of view how things are. But in the end, quite a few things have been produced and are being produced. And indeed, standardization is the meeting of people from different interests and trying to, in a transparent way, come to a solution that they can all agree to. So what can regulation do about this? Regulation had asked for things to fill out. Standardization committees have come. Who has come, by the way, actually? That could be interesting. Beside national bodies that are coming into ISO standardization, there are so-called liaisons. You find some industry consortia here. You find research projects like ABC for Trust or Credential or Prepare or Wisdom that maybe you know. And you find public bodies. You find the European Data Protection Board. Mainly, of course, the Article 29 working group has influenced many of these things, like the 27552 and other standards. And you find even, and indeed the committee is quite proud about that, the International Conference of Data Protection and Privacy Commissioners in a liaison role, so able to comment at any point in time. So this is possible. And of course, then it's something to see how it works out. So what does it tell about interplay between regulation and standardization? Standards are developed always to underpin regulatory provisions, to check whether and how fast regulation can be implemented also. And you try to see, can a regulation be really implemented in a way that things work out? Trying to write a corresponding standard can be useful. What can regulators do? They can refer to standards in regulation, or they cannot do it. Quite a few standards have a reference and are referred, some of them are not. So that's kind of quality control that I see that regulators can do. And they can mandate standards, especially in Europe. They can mandate status. European Union, European Commission can do that to European SDOs. I'm supposed Alessandro may tell more about that one. They can enable standardization organizations to be an existing and to have some funding. That, for example, happens in Germany with the German government contract with DIN, which is the German ISO and representative. DIN, it wouldn't be DIN if it hadn't had this contract with the government. They can participate themselves. Indeed, in Germany, this is actually combined with the participation. So the DIN German government contract says all German civil servants can go for free to the standardization committees. Therefore, you get this lump sum. Also, but that happens similar in some other countries also. Something that is only happening in a few countries yet, and maybe should happen more, is support access to standardization forward by those who cannot afford it otherwise. And vulnerable groups, consumers, for example. DIN has a consumer council. People can consumer representatives can attend any meeting and can send other people that they like. So, and all in all, lots of things are happening. More is happening, actually. And you have a kind of bubble bursting experience when you work in this area, because you see many, many different perspectives. I will later maybe report on the perspective about Japanese ethics with regard to privacy.
Okay.
But players know how to react to attempts to restrict their way of operation. Just that is to be known and when you try to regulate standardization.
Thank you very much, Kai. Excellent. And Alessandro goes on CEN and CLC, I suppose.
Yes, so I will complement Dr. Rannenberg's experience here with Can you hear me, right? Okay. From a European perspective, my own personal experience was of trying in the last decade, and some of my experience overlaps with Kai's, of course, of trying to establish better relationship within the standardization community, especially the European standardization community, and the regulator. Who is the regulator? Just to reply to our moderator questions, for us the regulator is the Commission. The Commission is a complex object in its very articulate organizations and different DGs. Almost a decade ago, an attempt was made to form some sort of a body inside the standards developing community, joining both the European standardization bodies, which are one is CENELEC and two is ETSI. Those are the two main SDOs recognized officially by the European Commission, the two that are empowered to provide European standards, ENs, for the people that are involved in the standardizations here. I'm happy that there are a lot of them. And representative from our regulators, i.e. the Commission and ENISA. That experience have a bumpy ride and a mixed results experience. Lessons learned from my point of view in standardization. We have two problems. One problem is just to be modern about it and practical, and how we can work in support of European policy, because standards are developed in support of specific policies, especially in Europe. From our point of view, our problem is that many people inside the standardization developing community are very wary of going outside the strictly technical standards developing, and just being involved in something like data protection, for instance, is difficult. It's difficult to bring experts from non-technical areas like legal, like the management, etc. So this is one point we have to do better at. The problem is that how standardization community works, the experts are there voluntarily by themselves or sent by their own organizations. So yes, there is a lobbying problem, because especially big companies can support a lot of experts and support them. I myself, if I have to participate in standardization work, I have to do it by myself and support by myself. And coming to, I don't want to criticize, of course, Dean, but there is also a problem in differentiation between national bodies. Because while Dean has government support and an enormous firepower in experts and so on, other governmental bodies do not have governmental support at all. So they are self-sustaining. Okay, so there is some kind of disparity in there as well. It's not particularly against Dean at all, which do outstanding work, but there is a problem almost representation in there. And that is for CENELEC, which is nation-based. So in CENELEC, you vote by nation, by country members. In ETSI, ETSI is a bit more prone to that problem of lobbying, because its membership is tiered towards a single organization. So a single organization can be an ETSI member, pays their fee. The more you pay, the more votes you get. And so that lends itself to, possible influence problems. So these two problems we have on our side. On the regulator side, we found out that, the commission in their different DGs and their difference in that do not understand very well how standardization work. They think of us as a provider. What Kai mentioned before, standardization requests, basically as it works now, they are unidirectional. The Commission asks for a standard, and they mandate the SDOs to provide the standards as a product. But sometimes you have difficulties in providing that, because experts at the table in standardization work come by their own volition. They are not employees, most of them. So this is a practical point from that standpoint. And another problem is that there is a lively debate inside the standardization community at all. Do we need European standards at all? I mean, are global standards enough? That is a problem we have to solve. And I'm thinking about data protection, not to mention ethics and all, are the European value structure we were talking about before different from the rest of the world, such as that we need the European standards in those fields? I think of privacy and data protection most of all, but not to mention ethics. Do we need the European standards as opposed to only global standards or not? I mean, we have to reply to this. That's it. We have to reply to this if we want to go forward. Thank you.
Thank you very much, Alessandro. So as a starting point, we now have heard your views on and options on the differences between the different standardization bodies. But let me ask you, what can we do about the danger that in standardization bodies, the battle which took place on the political level when laws were made is simply repeated? And those who lost in the democratic process come back with a lot of money and a lot of expertise, and in the very complex standardization process, they actually turn the world again in their direction and therefore undermine democracy. What are you able to do in the different organizations to avoid that this is happening? And do you have examples of this having happened, or for that matter, best practice examples of how this has been avoided in the past? So I think that is one question which I would like you to reflect on. And the second question is this. I think we face the challenge of bringing together an understanding of complexity and the ability to set out a way to implement what democracy requires from us. And I would say democracy is here the more important than ethics, because in the end, it's not the professors of ethics or ethics bodies which prime, neither should technology prime, or for that matter the market. If we say we live in a democracy, it's democracy which has the primacy. We listen to ethical arguments, we listen to what the market wants, we listen to economic considerations, but if we mean it with democracy, in the end it's the parliamentary law which at least has to take the essential decisions on where the rules should be going according to which we live. And this question is, for me, in the increasingly technologically complex world, how is it possible to make sure that this system still functions independent of the issue of abuse and trying to turn around things again later on in the standardization process? How can we equip democracy? And how can maybe standardization bodies and the experts and the expertise which is there help democratic process on the high-level rules to come to the right results? So, who wants to start on these two questions?
On the first, which is the simpler, by far the simpler, I think what is most important is that the European institutions, commissions, the various DGs, the Parliament as well, has a continuous dialogue with the standardization organizations, the European ones. There isn't such a channel, and there has to be. If you have a new kind of instrument in such a way that some kind of forum of communication which is bidirectional, where the standardization community can be involved before the Commission starts the standardization request, and all that process, a bidirectional dialogue could help a lot from my point of view. I'm not sure about what kind of regulatory instruments we can have about that, because it's very complex for many issues, but thinking about it should be very, very important.
Also on your first question, this is the reason why I say there should be something like a board, a barrier before a standard is actually passed into the world, yeah, where we ensure that what's coming out of standardization is not the industry power play game where they have the money to send the people, and then you see here on the slide, yeah, then the definition of what is pseudonymization, or the definition of what we understand by, let's say, legitimate interest, yeah, is standardized in the way that the industry likes it. We need some institution that has a say. A gatekeeper, sorry, I was waiting for this word, a gatekeeper. And It worked once when the Article 29 working group was the gatekeeper for the privacy impact assessment on RFID. They had to sign it off. And that is the PR that was then signed by Neelie Kroes. And what happened then? Then the whole standardization game started, and the PR standardization process was opened up again. It was run through the CEN body, and there was no gatekeeper. And what happened is that the PR for RFID that came out of that was completely lobby-driven and fell back on all the battles that had been actually won already on a political level. So gatekeepers, we need to think about gatekeepers. And let me tell you one thing. Today, the high courts are gatekeepers. The high courts are the ones who decide after all of those de facto standards have been created. They are today the final gatekeepers to say Facebook, Microsoft are allowed to do this or not. This comes much too late in the process. The societal costs are too high for that. We need to have the gatekeepers before.
Okay, so let's be very practical. Let's be very practical on this. I need to understand this. So are you actually saying, to be very practical, that the European Data Protection Board, which is already a body which has very strong technical competence with all these authorities, should actually be the gatekeeper for the standardization process before it's adopted? Because that would be the logic for me, not the Three Kings ethics. No. The European Data Protection Board would have to say before a standard enters into force, this we certify that this standard is in line with the law. Is that your concept?
Yes, that is exactly correct. Look at this slide here. Kai has brought it all up. He has shown us how the legal principles correspond to the standardization, and yes, and at the end,
okay.
the European Data Protection
I find this
Board.
a very interesting proposal to think about. Now I want the panel and the audience to think about arguments against this and arguments in favor of this, and at the end we will make a test vote. So the notion is the European Data Protection Board should be the gatekeeper for any standard which claims to implement any of the rules set out in GDPR. And gatekeeper means they would have to state before a standard enters into force that this standard is in line with what the law, as we interpret it, because that's what the EDPB does, that there is that this is right. So let's think about this.
May I make
Right.
a short argument against?
Please.
Okay,
Please, Alessandro.
it's better if the EDPB and the DPAs are involved since the beginning. You don't stand at the gate, wait for a standard to be developed, and then say yes or no. We already have DPA representatives in our group, and I hope to have more, and I hope to have the EDPB as well, but they have to be involved since the beginning of the development, and they influence the development when we are working on a standard. And then a word of caution. We used to say in Italy many, many years ago, quis custodiet ipsos custodies. Who guards the guardians? Who guards the gatekeeper?
Yes,
So
the answer is very simple. Of course, the final binding interpretation of any piece of EU law is a matter of the European Court of Justice. But what Sarah says is true. It can take much longer, and it has huge societal cost to wait for these final interpretations. The first ones who apply this is, of course, data controllers. They have to apply the rules. They have to make up their own religion. They have responsibility to do this with the advice of legal professionals. And they do it under the supervision of the supervisory authorities, which are the data protection authorities, which in the board, according to the regulation, set out their interpretation of how they see the rules. So you say, be careful. They should also be involved before. I would say yes, it both is possible. Both is possible. They can be involved before, and still you can have the stamp afterwards. So any other thoughts on this? Let's stick with this for a moment. Kai and then Alan.
Okay, yeah, let's come to the beginning to your question first. That was, how do we avoid that a standardization is undermining a democratic and democratically decided something? I think the first point actually has to come from the regulator itself, because one of the major problems that we have in regulation is we have a nice democratically produced law, but there is this paradigm of technological neutrality, and that is always given there as a paradigm, not to say as a dogma. And I mean, if you say you want to have your law technologically neutral, you open the door to any kind of body, including standardization bodies, to do the technical interpretation. If you want to have something very specifically democratically decided with regard to a technology, then make it a democratic decision and make the law specific to that, which is difficult sometimes, but of course indeed could actually be done in a few more cases. And while Sarah seems to have specific traumatic experience with CENELEC, to which I was not part of because I wasn't part of that committee, and I can report on an example of a mandate coming from the European Commission, DG Home actually, who said we wanted to have privacy by design for surveillance technology, and I still don't know what the democratic representation of that one actually was, because it was a commission exercise. There was no parliamentary discussion beside it. Standardization organizations came back to me and said, hey, this is a mandate that actually we could really not accept, because it will ruin the concept of privacy by design before we define privacy by design properly, and we'll end up with surveillance technology being an application area for it. So from that point of view, it's not always a word like, okay, something is coming from the European Commission, who are very much respect for many things, and into standardization, and then it's being ruined in standardization. It can as well be the other way around. Coming back to the gatekeeper model, there's a few practical things. I mean, obviously in ISO, why should ISO as a global organization, why should sovereign states like Japan, China, US, Kazakhstan accept a European body, EDPS, in terms of what they would be doing? So that wouldn't work.
Okay.
In CENELEC is, even though sometimes the Commission thinks different, not a European Union body. It is a European body. It has a number of members that are not part of the European Union. So one can make that proposal. But I think all in all, it is about the applicability of standards that the gatekeepers need to work about, which indeed they can do. EDPS and all the European Data Protection Commissioners, they can say, we find certain standards acceptable, and we would assign in our certification or in our checkings of systems that if somebody is following with a certain standard, we accept that. Or we say, well, this is a standard that is so poor, you don't even need to follow it. We have other things that we find better. And that, I think, is more efficient, honestly, than trying to regulate standardization.
Okay, Kai, I think we have now a few points which are, just to keep it very clear. The notion is not that the EDPS becomes the gatekeeper. The notion is that the EDPD becomes the European Data Protection Board. That means the assembly of all data protection authorities becomes the gatekeeper. What you have given as an example of the Commission asking for mandate, one DG, which is not the #1 privacy pushing DG, asking for a mandate, could be seen as a typical case of the executive wanting to go beyond the law. That's why we live in the rule of law, because we know executives, and by the way sometimes also legislators, but executives go beyond the law and they need to be checked. Yeah. And what you describe is that there is a problem in how the mandate for these standard bodies is given by the Commission based on EU law. And I think that is a very valuable point. We have to make sure that there nothing goes wrong. This mandate, again, of course, if it concerns a substance on which there is already substantial law, must be fully in line with this substantial law. Alan, and then I go to the audience. I have seen the fingers.
Thank you. So just a couple of reflections. So it's kind of curious, I think, Sarah, that I mean, we're both involved heavily in the IEEE ethics initiative, of which there are currently 14 new standards being drafted. And we call them human standards, because essentially what we're trying to do, it's very political actually, is kind of move the locus of standardization from wealth creation, growth, to human well-being. That's really important. But here's the thing. Why are our standards committees, 14 of them, not flooded with people from Facebook and Google and Amazon and so on? They're not. Now, you know, there are several reasons. Perhaps, you know, the work we're doing is just below their radar. I suspect that's not true. Perhaps more likely is that they think that they are de facto making the standards and that it doesn't matter, you know, they don't care in a sense what we're doing. And that really comes back to the democracy question, which I think is fundamental, as you said, Paul. The reason that I made the transition from being a professor of robotics to a professor of robot ethics is because public engagement. I did and still do a huge amount of science communication, and it was that, if you like, contact with the publics that sensitized me to the ethical issues in robotics and AI. And what I see as very important is that people like us get political. So, you know, not only do we understand, as it were, everybody, you know, ordinary people's concerns and issues and worries, but we also lobby government. You know, I'm regularly involved with UK parliamentary select committees, both Commons and Lords, and things like the All-Party Parliamentary Group on AI, also the WEF. So it's very important that we, in a sense, as a community, standards community, make that link between, as it were, the wider public and policymakers.
Okay, Alan, now audience. Fingers up. Okay, then lady here, 1, 2, 3, 4. We take 4 questions, then back to the panel and the next.
This interesting debate and discussions. My name is Aida Ponce del Castillo. I work at the European Trade Union Institute here in Brussels. And just a comment on the lobby political side of people sitting in standardization bodies. When you go there and sit, you don't speak for yourself, but you speak for the institution that you are representing. So you are a lobby of yourself. And this is true for any professor at a university and for any industry people. So at the end, everybody is a lobby for themselves. And if we see the list of people sitting and having the consensus of the standard, the majority are industry people, so it's industry bias, then a little bit few for academics, and then perhaps 1 or 2 people from government. But here, if you're speaking about democracy, you are missing the democratic aspect of standardization, which is people. And my question for any of you is, where are the civil society organizations sitting in the standardization bodies? And please don't ask me. You are welcome. Come and send us your comments, because that's not true. We have to pay a fee, which is very expensive. And we have to go to all the different sexy meetings happening in Thailand or Australia, Cancun, New York, to go. Who is going to pay that? So that is the problem of standardization.
Okay, that's a very good point. Thank you very much. I hear audience clapping. Very, very important point. Is the system rigged? That's what you're saying. Okay, next. On the right there.
So my point and question actually is very closely connected to the previous one, to do with the involvement.
Could you please say your name and academic background or something?
My name is Ansgar Cunha. I'm at the University of Nottingham, and I'm also a chair of one of the P7000 ethics standards from IEEE. So my point actually follows up very much on the previous person's around getting the public involvement, or at least knowledge of the fact that these standards are being developed and who's involved in this and those kinds of things. So the necessity of doing some kind of a communication that is accessible to people who aren't purely from this kind of technical point of view, because very much the there is this threshold of
micro. Okay, do we have another micro?
Hello? Okay. We're building a technical standard, so we need technical people in the room. For instance, so in the P7003, we've made an effort to get civil society groups involved and people with a social science background, and there is definitely a tension that the people from the more industry and engineering background.
Okay, thank you. We need a micro which works, guys. Do you still have one? Okay, next. I've seen one more hand over there. Yes, please, in the back. And then we move to the lady. And then here in front, we have two hands. Yes.
Hi. I'm going to say my name and who I'm with at the end of the question, so that people listening to the question, you'll see why. But my question is this. So I lead a privacy engineering team for a major tech company. I actually have 3 moral philosophers on my staff because of the ethical questions that we face, which really do test the wisdom of Solomon. My question is this. In order to have a really, to understand what the ethical thing to do is, it needs to be a broad discussion, right? We need to understand, so it needs to be a big discussion as possible. Where does society stand? How does culture stand? And this kind of thing. The challenge is that in our Twitter outrage society, I want to share my ethical dilemmas. I want to discuss them publicly because there are things that I just don't know what to do. But in this Twitter outrage society, it's very difficult to do that without damaging the company. So what I want to ask is, the ethicists, what can I do? What can you do? What can everybody in the room do to create a safe space to discuss these things? My name is John Grant, and I lead privacy engineering at Palantir.
Okay, thank you very much. But that is not the issue we're discussing here. We're discussing here whether, and I would like, this is the last question we take before we go back to the audience, I would like you to focus on this. We're discussing here whether the democratic process of making rules on a high level, which are essential and probably technological neutral, is then followed through by standard setting which is loyal to the democratic decisions on the issues which you just mentioned, namely the big issues in society should not be decided by your in-house philosophers and Palantir and so on. No, they need to be decided in democracy. That's the principle of essentiality. And we're discussing here whether the standard setting system is loyal to these democratic decisions, or whether the process is rigged in such a way that actually what is decided in democracy is not followed through in the process of standard setting. That's why we're also discussing here the gatekeeper function of the EDPB. That's our question. Please.
Yeah, thank you very much, Mr. Nemitz. I very much agree upon that. My name is Helene Jansen. I'm working at Cambridge University at the Computer Science and Technology, but I'm a lawyer from background. And I worked for a government for more than 10 years, and also in the privacy realm, in human rights more broadly. Yeah, and one of the things from that experience is that, well, whenever you have a separate institution doing the ethics assessments, I think you're parking the hot potato away. So it shouldn't be parked behind a wall like Facebook is doing right now. It's building an institution in Munich and say, this is the cool thing we are doing about ethics. No, ethics is from us all. And I don't have to follow up on what has been said about ethics and law and their relationship. And I think another problem with such institutions is that such a body cannot be held politically responsible or held to be account for what came out of a certain process. And then there's still, as Mr. Nemitz rightly said, the democracy perspective. Will it be guarded? Because ethics is and human rights are just one side of the coin. There are so many other sides. So we are talking about facets that need to be taken on board in weighing all these interests, I think. And
okay, thank you very much for the question. Now back to the panel. We will try to do a second round. A panel, now we focus on the question. First of all, do we agree on the principle of essentiality, meaning the basic essential decisions for society, how we would work, the big questions, are decided in democracy? What are the big questions? Well, if they touch on fundamental rights or the functioning of our democracy, like, you know, elections and so on. But then there is a follow-through, namely to set out how these big decisions, often technology neutral and set out in law, a law which is a compromise, where the formulations are always and often unclear because of democratic compromise. How is this then followed through in standard setting And how do we make sure that standard setting is loyal? And what is the role of the gatekeeper? Is there a gatekeeper, and how should it look? And specifically on GDPR, where we have a detailed law, should the EDPB be the gatekeeper? Because these are the bodies which are checked by legislation in their action, by judges in the end, and they have to enforce it. And I would say, that's my notion to you, it's very good if the EDPB, through this gatekeeper function, on the one hand acquires technical expertise, because then they will have to really discuss the technology issues with you, but on the other hand it's very good if they stand behind these standards, because that will make their work of enforcement more efficient. It will give these standards real teeth. If the EDPB says this is a good standard, it will make GDPR work better. Over to you. Who wants to go first? Sarah.
Well, I clearly take the position that the EDPB should be a gatekeeper and hence a role model for any kind of ethical questions in the technologies coming forth. I don't agree with my colleague that by just integrating data protection authorities or NGOs in the standardization process, that is enough. The reason being, lobbyists have immense money to send so many people to the Bahamas and wherever these meetings are taking place, and they're sitting it out. They're just playing the ping pong, and they don't care whether it takes 2, 3, 4 years. They just go, and the money, and they're paid for, you know, they earn a lot of money, whilst we, the DPAs, have hardly any staff to even check on the company problems that are out there. Not to speak of me as a volunteer and a university professor. So no, we do need to have the gatekeeper so that the companies have the motivation.
All right, that's a very clear position. Next.
No, hold on.
Sarah, come on. I mean,
I want to also correspond to the public questions here. 3 things. Also, the colleague here in the front said we are professors are lobbying for themselves. I don't agree. I don't lobby for myself. I lobby for society because I don't have any benefit. I don't get any money. There is a difference between a lobbyist who doesn't receive any money for the work he or she is doing versus lobbyists who are paid
Okay,
for.
Sarah, you cannot answer now 4 questions in this detail. We have only a few minutes left. Next.
I think we need both. Because, yes, the EDPB can be the gatekeeper, okay, but the DPA should be involved since the beginning. If not, we are the process, then have only
Okay, that's what you said in your initial statement.
Second,
anything new?
Second, yes, there is a problem with the funding and traveling. There is a problem also for independent experts. You have to fund yourself if you want to go there. So yes.
Okay.
Second, I mean, there's not only the industry, it's not black or white. We have problem of democracy also from institutions. I mean, are institutions democratic? Because DPAs, at the end of the day, are public institutions. So they are government agencies, okay? So they are not all white. There can be problems there as well.
That is true.
If a government is not at all democratic, their agency couldn't, theoretically, not be very democratic.
That is half true, because they are not government agencies. The DPAs are independent on constitutional level, which is a very special position.
Yes, it is true.
Next. But you're right, they can go wrong. They are subject to judicial review.
We have some governments that are...
Alan, do you want to say something or not?
Just reflecting, if I may, Paul, on the point that one of the questions asked about ethics behind a wall. And I have a very simple position, which is that if a company or an organization claims to be ethical, yet will not tell you who's on their ethics board or what the terms and conditions of those members are, or gives any kind of case studies of ethics in practice, then they are not being ethical.
Okay, Alan, thank you very much. Kai?
Okay. Gatekeeper, the question is where sits the gate? That is, I think, is important for me. I fully see, and that would be very useful and should be expanded more, an EDPB being the gatekeeper on which kind of standards are considered to be eligible, qualitatively high enough and good enough to fulfill GDPR provisions in terms of can we as EDPB accept them? If somebody follows those standards, would they follow our rules? I think that is a perfect role for the EDPB to put up, because that is actually the practical role, and where the DPAs then of course look after the individual data processing. Gatekeeper, and whether a standard could become a standard or not, I think is an impossible task. I lined out that CENELEC is not a European Union body, so it's a totally different something. ISO IEC is even further away. And we should not underestimate those kind of lobbyists that Sarah spoke so much about. They easily can found their own standardization groups themselves. You have a long list of industry standardization committees, consortia, and so on. And we haven't even talked about them. W3C, any trusted computing platform society, long list of global platform, long list of industry organizations who standardize things by themselves and are fully beyond any control of any government, and they do that. So if you put handcuffs to the, let's say, constitutional standardization organizations, you make their position even worse. So from that point of view, put the gatekeeping at the right place. By the way, IEEE is an interesting, we haven't discussed the constitutional setting of IEEE actually, and who looks after that one. And USB standards is an interesting task at that point in time, wireless LAN also. Anyway, gatekeeping makes sense when you put the gate at the right place, and I think the gate is here, is a standard eligible for GDPR implementation.
Kai, thank you very much. I would like to thank you. Our time is up. We have learned that it is good and very important that technologists and people involved in democracy talk with each other, and that we ask ourselves the question, in this technological world, how do we make sure that democracy primes? And for this, we have tried, and for me that was a learning of today, we have tried to define the roles of intermediaries between democracy and law, and the role of gatekeeping of the EDPB in relation to standard setting. For me, this was a useful session. I thank everybody for the discussion. I thank the technologists who have been here, and the people from the different interest groups. I found it very interesting to hear the European Trade Union Congress, Palantir, the academia. I thank the panel, and now I give for the final word the microphone to Marit.
Thank you very much. My task as a chair is to conclude the session, and I've only one more sentence. You have talked about the EDPB, so this is something we are represented at, but we had no voice here. But I want to say the GDPR is something, the task issue guidelines, recommendations and best practices are already part of the task of the EDPB. It is there. Of course, how much do they look at standards? That's a question. I'd like to promote it more, but the questions have not been answered. What about ethics? What about everything which is more than GDPR? And what about the full democracy, not only data protection? And I think this is an open issue. We probably have to meet again. Thank you very much.